what might be completely fine from a legal perspective can actually have like significant implications for your customers.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Andrew Antos and accountant Nick Tiscornia tell us why the money language matters in contracts. They review 3 clauses from 3 different master services agreements to underline how your drafting language choices can impact the money team. This is so important for proving your company's profitability as you contract. So let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I'm Mike Whalen. The purpose of the show is exactly what it sounds like. We take contracts, we beat them up, we're a little mean to them, occasionally finding the good. I'm here with a couple of friends in a special episode because there's 3 of us. I'm here with Andrew Antos and Nick Tiscornia. We are going to do something weird. We are talking through 3 documents. Let me show you what these guys are. They are all master subscription and services agreements. One of them comes from a company called Junio. The other one comes from GuideSpark, and the third one is coming from Workday. So these are all available on Law Insider. We'll make them available in the post, but to you guys, let me ask you, why are we looking at these documents? Andrew, what's special about these 3 master services agreements?
Yeah, so what's really interesting is that as lawyers, like we often think about only the legal implications of the language that we're negotiating or putting in agreements. But the really interesting thing is that once we actually get that agreement signed, there's a lot of accounting implications. And the reason why we're looking for at these 3 different agreements is that they have 3 different clauses that actually have pretty significant accounting implications. And so if you're a business or negotiating on behalf of a business, as a lawyer, like it's actually important to understand that what you might be negotiating, what might be completely fine from a legal perspective, can actually have like significant implications for your customers. And so what we're gonna do is like we're gonna look at these 3 different contracts and 3 different clauses and walk through what those implications might be and why it's important to know these.
That's right. Andrew, with the T's, we are doing like a Venn diagram of nerdery. We're crossing the streams to make a Ghostbusters reference that you guys are probably too young to get. But yeah, we are bringing 2 kinds of nerd together. That's why we have both Andrew and Nick. So Andrew, let's talk about you quickly. Why you? And we'll talk about why Nick. Why are we discussing this with you in particular, these documents with you?
Yeah, totally. So, I was a corporate lawyer in my previous life. So originally from Europe and came to the US 5 years ago to do my LLM at Harvard. And like as a corporate lawyer, I had to review a lot of documents, not just agreements, but like all kinds of documents. And I always wanted to automate as much of it as I could. And I met a guy at MIT who was working on a natural language processing engine. And we decided to automate document review for the world. And we spent years building this natural language processing platform that can understand any type of a document. And then we started looking for like, what are the best applications for this, right? Our initial logic was like, if people are reading a lot of documents every day, if we can help them not having to read all of these things again and again, then that could be a really big impact on the world. And so we built that platform, and then we started looking for use cases. And I met Nick through a friend who was on the legal team at Slack, where Nick was at that time, and Nick was on the revenue accounting team. And I started talking to him about his document review workflows, and we ended up working together.
Yeah, Nick, we got a brief taste of your background there. Tell me about your background and how it relates to the documents we're talking about today.
Yeah, absolutely. So my background is, 100% in accounting until I came to Clarity. So before Clarity, I was at Slack for 3 years, went through ASC 606 adoption, which is the revenue accounting standard that every company that has a contract with a customer has to conform to. Went through the IPO there as well. Before that was at a company called Riverbed Technology in a similar capacity. At both companies, I ran the technical revenue accounting team, which was in charge of reviewing the MSAs, master agreements, order forms, purchase orders with their customers in order to validate that those contracts and the accounting related to those contracts were in line with ASC 606, as well as the policy that each company had developed for revenue accounting specifically. Before that, I was at PwC in the audit practice and a couple other places. So really a career focused in accounting.
Well, thank you guys. So what we're going to do now is go to the actual documents. I'm going to start first with this one in Junio. And what I'll do is point out specific sections in these documents. And then you guys can talk us through real quick how there's like this financial overlap that matters and also the legal part. So in this first document, we're going to jump down to 3.2, which has to do with acceptance. Andrew, tell me about this acceptance section in this document.
Yeah, absolutely. So acceptance clause basically says that the customer can inspect and review and test whatever you're selling to them. So in this specific case, it's software and services related to the software. And so basically, rather than just saying, hey, I'm buying software and like you start paying on the date when you sign the contract, what this actually says is like, that the customer can review, can test the software, and can decide if it's acceptable or if it's not acceptable. And if it's not acceptable, it sets up certain process on how can that be kind of revised or revalidated. But like if it really if you don't meet the test criteria as determined by the customer, ultimately it terminates the contract. And so that's the legal reading of that clause.
Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. Yeah, Nick, tell me, I'm looking at this and I don't know that I've ever, is this a common section actually? Let me ask you, Andrew, is this like this sort of format where there's the test and then sort of the rejection of the test? Is this a normal protocol in these kinds of contracts?
Yeah, it's pretty normal. I think like this clause specifically is a little bit more worded than usual, has a little bit more details in terms of the actual procedure and so on, and exactly how it's gonna work. So it's a little bit more prescriptive in terms of the process, which I actually see as a good thing. It means that it's fairly certain how the procedure should work. But generally speaking, it's fairly representative. Most of the time, it's going to be a little bit shorter, a little bit more ambiguous, but not conceptually different.
But Nick, money-wise, this is bugging you. What's bothering you about this section?
Yeah, absolutely. So an acceptance clause could give you pause to recognize revenue at all on that contract, because if the customer has the option to review, what you've delivered to them, in this case, software and services, and say, no, this doesn't conform to the contract or what I would want to see in this product, they might not pay. You might not be able to even collect on that. So you wouldn't be able to recognize revenue until either that acceptance period has expired or passed, or they give you, an explicit acceptance of we accept this this product, right? It's a little different in like computer hardware or actual deliverables, where you might have a set of specifications, and if you can prove that the product you delivered is in line with those specifications, even if the customer, has this right to accept in line with those specifications, and you can prove that they're in line, then maybe you can recognize revenue and make a case for yourself there. But if they have, the ability to unilaterally tell you, I do not accept this, you might not be able to recognize revenue until they do give you that acceptance. For services, it could be a little different. So you might put an extra section in that clause that says, if you don't accept the services that we provided, we have the right to rework that at our own cost. We can come back and provide those services again and make it, conform to the contract itself. If that's the sole remedy for the acceptance or non-acceptance by the customer, then it might not cause a rev rec issue. So it's kind of a gray area that you would have to assess as an accountant. Do I think there's a probability that the customer will not accept and that we won't be able to get the fees and we won't be able to recognize revenue?
So to make a terrible analogy, when I buy something from Amazon and then want to return it, there was revenue received. We can say, okay, you made the money and then, they paid it back. Where in this situation, that ability to refuse, there's some ambiguity around like, when did money get made? Which screws up the math, guys, and nobody wants that. So similarly, let's jump over to the GuideSpark agreement. I'm going to jump down to 6.3, termination for convenience. God, I just love the word convenience in a contract. Andrew, tell me about this section.
Yeah, so termination for convenience, or sometimes called termination at will, is basically the mother of all termination clauses, right? It gives the customer, or both parties in some cases, the ability to just wake up one day and say, I don't want to be a part of this anymore, and just terminate the contract, right? Some have period of termination, right? So in this case, like it actually says 60 days. So it's not like the contract will terminate, if I wake up and today and decide to terminate, it's not going to terminate today, still going to be 60 days. But I can just feel like it. Like there's no reason that I have to give. And that's really non-standard in bigger agreements like this one. It's quite common in NDAs and very, very simple agreements that actually don't involve an exchange of money. But for actual kind of like product related or services related agreements, this is pretty severe. Right. And so like think about being the customer here. You have all the power in this relationship pretty much. And then, conversely, as the one providing the product in this case, like you're waking up in cold sweats every morning and just like checking your email is like, did they terminate? Did they terminate? Did they terminate? And so it's that kind of a relationship, and that's super, super, super non-standard.
That's company ownership anyway. Well, and it says, Nick, in here, companies shall be responsible for payment of any amounts due through the end of the then current subscription term. What are you seeing here in terms of, there's a bit of talk about prepaid and unused fees. Where's the money part that's bugging you here?
Yeah, so there are definitely nuances to a termination for convenience. So the concept, just from an accounting perspective, is that this is going to impact the length of the contract, right? So if the customer has 60-day, termination for convenience with 60-day notice, and they can recoup all of the fees that are related to anything after those 60 days, then that might be considered or would be considered a 60-day contract from the entity's perspective. So they can't put any of the remaining fees on their books at all, right? So it's a 60-day contract, short term, which is very impactful when you're reporting, how my revenue is going to look over the next year or 2 years or 3 years. If there is a significant penalty, which there is in this contract, indicating you will not get a refund for any of the prepaid fees that you've already given, that wouldn't cause this to be a short-term contract. You can actually say this is a one-year contract. Even if they cancel and stop using the product after 60 days or halfway through the term, we can still recognize the revenue because they can't get a refund on that. And there's a few different types of nuances on that significant penalty. It could be a stated fee. It could be the remaining fees in the contract. The main important factor for a termination for convenience for like a SaaS company, for example, is that at least none of the fees that are related to services provided through the termination date can be recouped, right? So I'm recognizing revenue on a daily basis or a monthly basis. As long as I recognize revenue correctly for those months, I don't have to do any retroactive accounting, then that's okay. Although I'm not, putting the rest of the contract on the books. So that's very impactful too, from a perception perspective for companies.
And Andrew, jump into the Workday contract, the third one. This one's got all kinds of legal speak. You're going to have to translate for me. This section is number 5, the right to reduce FSE or SKUs. It's an option. Talk to me about this. Explain the legal piece to this.
Yeah, totally. So option, if you look at option, it's basically just a unilateral right of the customer in this case to decrease how much product are they buying from you until a certain date. So option basically always needs to say, there needs to be a date until which you can exercise it. It needs to be always unilateral. It can only rest upon the decision of the customer in this case. And then there needs to be some kind of a description of what's happening with the price or with the volume that has an impact on the price. And so what we're basically looking at here is that the customer can, based on the changes in their business, can basically decide that they will be buying less product from you at some point. And so this is a fairly, again, like an extreme, fairly like non-standard way of handling a situation where the customer, for example, comes to you and says, we really want to buy this product from you, but we just don't know how much of the product we need to buy, right? And so what you're saying is, let's say that today you might be buying $1 million worth of product, but then you have the option to decide, in the next 6 months, for example, to say, yeah, I actually feel like buying only $750,000 worth of the product. And so again, like the interesting kind of commonality here is like the dynamic is that the customer is in the driver's seat.
Yeah, Nick, I feel like from my contracts class in law school, if I was to say what's the purpose in a contract, it's who's paying how much and what are they getting. Like this seems like It would really screw up your world. Tell me what you're seeing on the money end, why these sort of options are messing up your math.
Yeah, absolutely. So every revenue accountant, when a contract comes in, has to assess, what is the length of this contract and how much, what are we going to deliver, right? What are our responsibilities as the entity, and what is the customer's responsibility? What are they going to pay? And that could vary, right? It could be variable, and hopefully that's stated in the contract, and you can actually do an assessment up front. So I would say, here's exactly what's in the contract. Here's the options that are provided to the customer. I have to make a judgment call and say, do I think they're going to exercise this downturn clause? Do I think they're not going to? I can use history of other customers or history with that customer to make that determination. But eventually I'm going to have to come up with an assessment and say, here's what I think the contract will be for the term of the contract. And that could be 1 year, 2 years, 5 years. And I have to assess that up front and recognize revenue in line with that. Now, every once in a while, I have to do an additional assessment, right? So whether it's when the option expires or on a quarterly basis or on an annual basis, and that would be up to your accounting policy. And, again, like many things in ASC 606, there's some subjectivity here. But as long as you can explain yourself to the auditors and they think that it applies to the standard correctly, then you should be good to go. But periodically I'm going to reassess this and say, have things changed? Do I think that the contract will change in any way based on new information that I've received over this time? So, if there is a downturn clause, I think it's likely that they're going to exercise that option. Then I might account for the contract at a lower value for the entire contract until that option exercises or until expires, or until they exercise that option.
Well, Andrew, I'm stepping back for sort of big principles, and I feel like we're having a lot of conversation about how to make the accountants happy, and like the bosses probably like the accountants more than they like the lawyers, but let's not act like we're all going to the company party and we're the cool kids, right? Why, from your perspective, in the complex environment of a company and of a deal like this, why is it so important to make the accountants happy, to get this kind of clarity for the accountants to do their work?
Yeah, I mean, if you think about it, like contract is just basically a way to record rights and obligations of two or more parties with respect to some kind of a business transaction that they want to carry, right? And so like in this case, the company wants to sell whatever they're selling for a certain amount of money. And because they're better at building whatever they're selling or providing it, they're going to make a profit, right? And making the profit is really important especially with relation to your cash flow, right? So you want to get the cash in the company. You want to start recognizing the revenue as soon as possible after signature of the contract in the kind of fullest possible scope. And so the commonality that basically we're talking about here with all these three clauses is that they somehow like reduce the scope of the contract, either from a time perspective or from a value, monetary value perspective. And so if you're a lawyer that's just negotiating the contract to get that contract done, and kind of like you don't look left or right, like what are the actual tangible implications for the business, that's actually pretty hurtful for the company, because you're actually not achieving the main objective of getting to a contract that will allow the company to sell what they're selling and getting the revenue in the maximum possible state. And so from that perspective, it's really important to understand what are the downstream implications of these actions, right? Those implications, you kind of like need to think about it in the negotiations process, because once you get to a signed contract, the accounting team will operationalize it somehow, but it might actually be hurting the company.
Yeah, as we've talked about on the show before, if you're going to turn contracting into a strategic advantage for the company you're working with, you got to think about the supply chain, all the people who are involved in turning that advantage into something that turns into profit. So Nick, let's say we've got an attorney who's in-house, who's drafting, and who wants to be mindful of that supply chain and make the accountants happy. Nick, how do we make the accountants happy? I mean, they just complain. We just want you to smile, Nick.
Right. Yeah, I mean, at the end of the day, the accountant's job is to get the accounting right. No matter how the contract was negotiated or what's in the signed contract, that's going to be the source of truth. That's how you're going to apply the accounting standard and your policy. However, an accountant, a revenue accountant specifically, can be very influential over that negotiation process, because they can take that information that they have in signed contracts and go back to, the legal department and the sales group and say, hey, we're really negotiating these terms that are impactful to our business, and it's impacting how investors look at us, or how, executive management is assessing the company as a whole. So it really has a macro impact. And I think open lines of communication between these groups, which is sometimes very difficult depending on the nature of the company, is super important, right? You have to be able to have that relationship to go back and say, this is how this is going to impact what we're doing from a company goals perspective. And yeah, I think, again, an accountant can do the accounting no matter how you do it, but you want to make sure you're achieving what you want to as a company.
Well, I respect this noble effort to become the cool kids at the party. Thank you, Andrew. Thank you, Nick. Andrew, if people want to reach out to you and learn more about your work and how to make the accountants happy from your perspective, what's the best way to get in touch with you?
Yeah, please either reach out through our website, which is tryclarity.com, clarity with a K, so tryclarity.com, or you can just contact myself or Nick on LinkedIn. I'm Andrew Antos and Nick Tiscornia. We respond to every single LinkedIn message that we get, so please reach out there.
And Nick, any other info on how to connect with you and maybe invite you to all the parties?
I think Andrew summarized it well. I can always be reached at nick@claritylaw.com as well.
Awesome. Well, I appreciate you guys joining us, and I appreciate all of you watching. Remember how important it is to make your accountant happy. You got to make everybody happy on the supply chain. We will see you guys on the next episode of the Contract Teardown Show, and information for this episode, including links to the contracts, will be over at lawinsider.com/resources. We'll see you guys next time. Thank you.
Thanks so much, Mike.
Thank you.